Motion re European Union Common Fisheries Policy. I would ask Deputy Pádraig McLaughlin to move the motion.
I move the motion. Last Caller, should we wait until the Minister comes into the chamber? I'd be happy to wait. Oh, the Minister's here. Okay, thanks, Minister. Minister, in relation to this issue, I want to state at the outset, not just on behalf of Sinn Féin, but on behalf of all the fishing organisations I've spoken to, that we support a penalty point system being put in place. It is essential, but that system must be fair and it must be just. And it's important to read into the record the history of how we've got here this evening. The previous statutory instruments that were brought in by the Ministers and the Department of the Marine were ruled illegal by the High Court on a number of occasions. It then went to the Supreme Court, and the challenge from the fishermen were upheld. Then we had a situation where a statutory instrument, number 89 of 2018, was put into place by Minister Michael Creed at the time, signed by himself. And this Dáil came to debate an annulment motion, just like this one tonight. And for the first time in the history of this state, the Dáil voted to annul a statutory instrument. It had never happened before, it's never happened since. That was the immensity of what happened during those number of days in May of 2018. And I'm going to read into the record some of the quotes that were said, and of course we'll have 5 minutes later on when other colleagues from the government will join us here. But I'm going to read into the record what was said at that time. So the proposer of the motion, who deserved great credit, Pat the Cope Gallagher, former TD in Donegal, former Fisheries and Marine spokesperson for Fianna Fáil, he brought forward the motion. And to quote what he said, "The statutory instrument states that the determination panel and the appeals officer, if such is the case, would determine on the balance of probabilities. We do not accept this principle of a lesser burden of proof. It is grossly unfair to the individual to lower the burden of proof. We will be proposing a statutory instrument we have prepared under which in both instances the case must be proven by the state beyond a reasonable doubt in line with common law principles." Hear, hear. He also said, to put in simple language, the proposed structure under this statutory instrument would be similar to in Garda Síochána detecting an infringement, being allowed to select the judges, to adjudicate on the case, and finally handing down the eventual judgment. Now I'm going to quote from the current Minister of Agriculture, Food and the Marine, Charlie McConalogue. This is what Charlie said on the record on May 23rd, 2018, here in this chamber. He said, "We need to take on board the needs of the fishing sector. We need to avoid the possibility of it being struck down in the courts again. The Department's track record in introducing a penalty points regime has been poor. Given that on 2 occasions attempted statutory instruments were struck down following appeals to the Supreme Court, reflects very poorly on the management of the issue heretofore." He also said, "The key points that remain to be addressed relate to the burden of proof. The current approach in the statutory instrument deals with the balance of probability," this term again, the balance of probability, "rather than having to prove beyond doubt, which is normally the case where a criminal sanction is being pursued. The role of the SFPA, the Sea Fisheries Protection Authority, permeates the statutory instrument at all stages, which was the basis on which the Supreme Court struck down the previous statutory instruments." So you can see again and again the spokespersons, their concerns from the Fianna Fáil party. Deputy Dara Cleary, former Minister for Agriculture, Food and Marine, he said, "The burden of proof, the rights of appeal, penalty points capacity and some sort of realistic appeals timeframe," that were his concerns on the record. He also said, about the fishing community, and I endorse 100% what he said then. That sense of alienation is getting deeper. Many of these communities are dying on their feet. The way this issue has been handled is adding to the sense that marine issues are not a priority, not just for the government, but for the central government system, full stop. If we deal with this collectively, as an Oireachtas, and deal with it in a progressive way, working together, we can start addressing these issues and lay some sort of pathway to addressing that alienation. I agree with everything they said. The motion was passed. Historic motion. Then, within the days that followed, in fairness again to Pat the Gob Keller, not only did he have this statutory instrument annulled, he put forward a document, and I've read through this, with amendments to the previously put forward statutory instrument. There it is there. He did this in full consultation with the fishing industry. There's his amendments that would have solved the problem. But nothing was done. Nothing was done. Time drifted on and time drifted on. And then we come to August the 28th, 2020. Micheál Martin, as acting Minister for Agriculture, Food and the Marine, as Taoiseach, signs off on a statutory instrument, 318 of 2020, which is almost identical to the SI of 2018. Almost identical. The core issues of objection were not addressed. I actually found out about this on a Friday evening, and I thought it must be a misunderstanding. At first I thought it clearly is a misunderstanding. There's no way he's done this without consulting with the fishing industry. And then I found out the next day, no, he actually did do this. And then there was a sense of he must have been misled. He didn't understand the full implications of what had happened. And my own party then brought forward and put on the order paper this annulment motion that's been debated tonight. But we held back because we talked to the fishing industry, and they said, we believe that if we engage with the new minister, Charlie McConlogue, that surely he will see the need to amend this SI. Surely he will see the need to put in place Pat the Gob Keller's amendments. By the way, I emailed those amendments to the minister. I still haven't had a substantive response to that email. Nothing. The producer organisations then meet with the minister, and still they believe that, we can turn this around. And they're bitterly disappointed with that meeting. They then send a letter to the minister on the 18th of September, Minister Charlie McConlogue, and they identify the 4 issues, this issue of a burden of proof that is on the balance of probabilities. I mean, we all know that prosecution has to be beyond a reasonable doubt. That's the threshold, but not for fishermen, it isn't. The points remaining on a licence, even in the event that the person or persons have been exonerated in court. The points that are attached if the licences or the tonnage is sold on multiplies onto the next person. And then, of course, that they can only apply to the High Court on a point of law. They are the 4 points that are in the letter to the minister. No substantive response. So we are here tonight because, incredibly, Micheál Martin has signed an SI which is in clear defiance of everything they did in 2018 as a party. Micheál Martin actually voted for that motion on the 29th of May, historic motion, 29th of May 2018. I'm appealing again tonight to the government to do the right thing. I'm appealing particularly to the Fianna Fáil party, the TDs, and I could have read quote after quote after quote. I invite anybody to read the Dáil record, a whole ream of Fianna Fáil TDs, and I wouldn't challenge a word they said in that debate. Everything they said was spot on. Every one of them, spot on. Powerful stuff. And here they are as a party. How are they going to stand over this? This is just profoundly unjust. So to sum up for my 10 minutes that I have here to open up. We are dealing with Brexit. I was speaking to a senior fisheries spokesperson in recent days who said that this is the biggest threat to our industry in 100 years since the foundation of the state. We've seen the submissions they made to the Oireachtas committee in the previous Oireachtas. They are deeply concerned. So I'm appealing that the government do the right thing, re-engage, even if you vote this down tonight or tomorrow night when the vote takes place, and I'm really hoping that you won't. But even if you do, there's still a chance to amend this. Do the right thing. The South and West Producer Organisation have already made it clear publicly they're going to challenge us in the courts again. They shouldn't have to. We've already spent a fortune of money, where our Department of the Marine has gone to high courts and the Supreme Court defending the indefensible. Will they do it again? Will they do it again? Is this where this will go? Back to the courts again? We can avoid this. Let's use a template. So I'm not being party political. There's Pat the Cope Gallagher's amendments. What's the Attorney-General's view on these amendments? Have you sought the Attorney-General's view of these amendments, if they are in line? I've no doubt that they are. You know, has there been a proper engagement with this? It's just an absolute scandal, quite frankly, how this has been handled by the Taoiseach. And I'm shocked that there hasn't been a solution found, that we're here tonight. We actually didn't want to do this debate. We would have never put this motion forward as a PMB unless the fishing industry told us that you may go ahead, because we're not getting there ourselves. So that's my initial appeal, and I'll hand over to my colleagues now.
Thank you. There are just under 9 minutes left and 3 speakers. Deputy Maid.
Thank you. Fishermen are one of the most important sectors of our economy. They work in the most dangerous and sometimes harshest of environments. The one thing they should not face is a point system that is not fit for purpose. This motion is about fair regulations. It's about the type of regulations promised in the programme for government that commits to implementing a fair EU point system. However, nothing about the contents of this statutory instrument 318 is fair. In no other member state of the EU does a system exist like the penalty point system that is in use in this state, where the burden of proof is based on the balance of probabilities, where points remain on your fishing licence although you have won your case in court, where the appeal system is not a true appeal system because the number of penalty points cannot be changed no matter what the mitigating circumstances are. There have been many attempts to deal with this issue, and one would assume we as Oireachtas members would be hearing in detail how the High Court and Supreme Court judges have been addressed and implemented with any new regulation. There are differences between this SI, signed and then annulled in 2018, and the SI, but they are only slight, and so leaves the livelihood of fishermen in peril. I have strong reservations about the constitutionality of this regulation, and if it weren't for the scrutiny of the fishermen, my Sinn Féin colleagues, we wouldn't have had the opportunity to try and stop this sinking ship. Because of this SI is not annulled, it is sure as night follows day that there will be more challenges in the courts. This SI, if left unamended, will damage coastal communities across the island, including my own county of Wexford, from Rosslare to Kilmore to Duncannon. I'm appealing to the government to do the right thing here, to treat the fishermen in a fair and equitable manner. I ask that all deputies support this motion to annul SI 318 in the name of fair procedures and justice for all.
Thank you, Deputy Rose Conway.
I want to thank my colleague Pádraig McLaughlin for bringing forward this really important motion. The commercial fishing industry provides an essential source of income for many people and communities along the coast of Mayo and in my own community and many communities across the island. We have always asked that the rules that were brought in are proportional and reflect the realities on the ground. But too often the regulation from the EU are designed by member states with far larger and more industrialised fishing industries in mind. But the blame here lies closer to home, with successive governments' mishandling of bringing forward a system that works and is fair. This is despite the best efforts of fishermen across the country to engage constructively with the process. The statutory instrument Sinn Féin is trying to annul was designed by Fine Gael and as was said, was opposed by Fianna Fáil in opposition and now supported by Fianna Fáil in government. So it's no surprise that the electorate are running away from Fianna Fáil. They change their position so easily, it's impossible to know what they're voting for. There are a number of serious issues with it. The most glaring is the fact that fishermen will not have the right to appeal to the High Court after this is dealt with by the determination panel and the appeals officer. This has been going on for far too long and has given enough time for a detailed review to have been conducted by the EU, and the need to modernise and simplify the existing system. They have accepted that there is insufficient data to accurately enforce the system. The European Court of Auditors and the resolution by the European Parliament have all shown that the fisheries control system has deficiencies and overall is not fit for purpose. Despite the EU's recognition of the systematic weakness in the approach, the government thinks it's appropriate to design the system in such a way as to remove any legal recourse for fishermen, even when their livelihood is taken away.
Deputy Louise O'Reilly.
Margaret Lascown-Corla. I want to start by thanking my colleague Teachta McLaughlin for bringing forward this motion, and I want to join with him in saying it really shouldn't be necessary. This was actually the last thing that we wanted to have to do. In fact, a lot of the heavy lifting, as the fishing representative organisations believed, had been done, that the argument had been won, but now we see a complete about turn from Fianna Fáil. Now, of course, nobody is going to be surprised by that, or indeed the fishing communities that I represent won't be disappointed by that, because they know Fianna Fáil, they know that they say one thing and they know that they will do another. This motion is intended to be constructive. It was devised following consultation with the representative bodies, presumably the same representative bodies that Fianna Fáil consulted with before drafting the amendments when they did very, very recently. And I think, you know, on behalf of the communities that I represent, and as someone who grew up in the town, I didn't grow up on the coast, I have been absolutely taken with the manner in which the people of my own community, the way that they work, the way that they are. They're a very solid, very close-knit community, but they've long come to expect disappointment from successive governments. They've long come to expect to be neglected. They've long come to expect to be the last to be dealt with. They know that they are very low down on the list of priorities, and indeed what's happening here this evening is proof to them that this is a fact. So the people in Skerries and Balbriggan, they don't have the biggest fleets, they don't have a massive harbour, but they certainly are members of a fishing community that we have consulted with. And, you know, we're not opposed to the penalty point system. They are not opposed to the penalty point system. What they seek only is a system that is fair and an appeals process that is fit for purpose. And the fact that that's too much to ask from this government, I think it says a lot to those fishing communities, to their families, and indeed to the people like myself who represent them. So I'm calling on my constituency colleague, Dara O'Brien, to do what he said he was going to do, to be as good as their word as recently as 2 years ago, and to support this motion and to stand up for fishing communities.
Deputy Pat Buckley to conclude.
Again, I want to thank Deputy McLaughlin for bringing this extremely important issue to the floor tonight. And it's kind of strange that we're here in 2020, and yet a while ago it was mentioned this was already annulled by the Fianna Fáil party with the proposal of Pat the Cope Gallagher at the time in May 2018. And many of the speakers have made the valid points that the fishers are not opposed to an introduction of penalty points. What they want is something that's introduced and fair. And you've heard it in many other discussions before that a bad law is an unjust law. And when you're taking families' livelihoods away from them on some ridiculous, absolutely ridiculous stuff, like where is it? The scheme is proposing sanctions that can remove the livelihood of fishers on alleged infringements on the balance of probabilities. Noting this would be beyond a reasonable doubt if in any other circumstances. You couldn't make it up. You actually couldn't make it up. And yet, because somebody has a probability or a belief that, you know, people can lose their jobs. I was very surprised to see in May 2018 my other TD in my own area of East Cork, Deputy Dave Staunton, actually voted against this. And I mean, he, along with other TDs in East Cork, represent fishermen from Youghal, Ballycotton, Guyleen, Roaches Point, all the way to Cove. I'm very, very surprised with this. What I would say to you, and I would appeal to you, it's about doing the right thing, addressing the fairness here for the fishermen and families, that please do the right thing. support this tonight, annul it and get things done right. Go to Míle Mágat.
Go míle mágat is seachta. A rest go díon míle to Sarah.
That's Cam Corla, and I'll be sharing my time with Deputy O'Sullivan. I'd like to thank Deputy McLaughlin and his party colleagues for providing me with this opportunity to discuss this very important motion in the House this evening. The 2009 EU Fisheries Control Regulation established a community control system for ensuring compliance with the rules of the Common Fishery Policy, the CFP. One of the important tools introduced by the control regulation is a point system for serious infringements of the rules of the CFP, applicable to the licence holder of the fishing vessels and separately to the master of the fishing vessel. This part of the control framework was introduced in order to address concerns about the lack of a level playing field across the EU in fisheries control and the treatment of vessels from different member states. These rules are designed to ensure that fishing in EU waters is sustainable and that the long-term interests of fishing and coastal communities are protected by ensuring that our precious fishing resource is protected. The point system is intended to complement the normal sanctioning system in member states for serious infringements and promote a level playing field on control within the EU. These systems were due to be implemented in 2012. Ireland is responsible for the control of all fishing activity by Irish and foreign fishing vessels in our 200-mile zone. The points to be assigned under the new SI will be applied to both Irish and foreign fishing vessel licence holders held responsible for serious infringements committed within Ireland's 200-mile zone. The idea of a point system is that it is graduated and proportionate, with only repeated serious infringements resulting in the most serious penalties. Such penalties are, of course, avoidable completely through compliance with rules that are well established. These new regulations are required under EU law and have been since 2012. All other coastal member states have implemented the EU point system. Ireland is in breach of its EU legal obligations as a result of its failure to implement them up to now. As a result, the EU Commission, under infringement proceedings, issued a reasoned opinion to Ireland in July 2020 and has given Ireland 3 months to respond. The implementation of these regulations was already overdue, but their urgency has been amplified by this reasoned opinion. In addition, the European Commission has formally suspended payment to Ireland of EU co-funding payments under the European Maritime Fisheries Fund, the EMFF, operational programme. This suspension will continue indefinitely until Ireland puts in place the necessary legislation and administrative systems to comply with the EU point system. Unless the regulatory lacuna is addressed immediately, we face an increasing financial cost to taxpayers of this country. EU funds for control and enforcement available to Ireland under the EMFF are €37.2 million over the course of the programme. As of September 2020, 13.5 million payments were withheld. A further recoupment claim due to be submitted later in 2020 will result in the amounts withheld rising to €24.5 million and a total of 37.2 million is at risk for the full programme, as I said earlier. SI 318 of 2020 represents an opportunity for us to fulfil our obligations under EU law while providing a fair and balanced point system to ensure the stability of our fishing industry. The SI takes on board in full the findings of the related 2017 Supreme Court judgment that the procedures followed are fair and in accordance with best practice. It separates the detection and determination functions by putting in place independent determination panel as well as an independent appeals officer, all of whom are legal professionals nominated by the Attorney-General. Both the determination panel and the appeals officer must grant the licence holder an oral hearing if he or she so wishes. Under the new SI, the accumulation of points for persistent serious infringements of the rules of the Common Fisheries Policy will lead to the suspension of a sea fishing boat licence for a period from 2 months to 1 year. In extreme cases, persistent serious infringements could lead to the permanent withdrawal of the licence. But it's important to note that the EU control regulations provides that if the licence holder does not commit within 3 years from the date of the last serious infringement, another serious infringement, all points on the licence shall be deleted. The new SI includes a number of, but not all, amendments sought as a result of the consultations with the industry. The new arrangements are the minimum required to meet the tests of proportionality, effectiveness and dissuasiveness required under the EU law. The adoption of this new SI is also in line with the commitment in the programme for government. I believe that all in this House want to see a strong and vibrant fishing industry that supports employment in our fishing fleet, fish processing and ancillary activities in our coastal communities. SI number 318 of 2020 is necessary to protect the vast majority of our law-abiding industry, to preserve this precious and valuable resource for all Irish fishermen and for future generations. I am confident that the new enhanced points system provided for under the SI will play a vital role in delivering on the common fisheries policy objective of ensuring proportionate, effective and dissuasive penalties for serious infringements, and contribute to a level playing field in fisheries control across Member States. The point system is necessary as an effective measure against the small, either foreign or Irish, small numbers of operators, foreign or Irish, who break the rules. It is necessary to protect the vast majority of our law-abiding industry and preserve the fish stocks for all fishermen and for future generations. I join with my colleagues and urge this House to protect the future of our fishing industry and to support the government counter-motion.
Thank you. Deputy O'Sullivan.
Thank you, and thank you, Minister, for sharing your time with me. I'm here representing West Cork, home to Castletownbere Port, Ireland's premier whitefish port. So at the outset, I think it's very important for me to say that I'm not happy with elements of this statutory instrument. However, I think it would also be misleading of me to say that I felt there was a realistic possibility of a replacement SI at this stage. But I do feel that I want to take this opportunity in the Chamber today to outline some of the problems and some of the issues that I have with this particular statutory instrument. And I really hope, I suppose, Minister, and we have the Minister for Agriculture here as well and Marine, that you listen. You listen to my concerns, you listen to the concerns of the fishing industry, and indeed the concerns of the opposition that have been pretty well made, and they are representing concerns made to them by the fishing industry at large. So that's an opportunity we have, because there is a whole host of massive challenges facing Ireland's fishing industry, an industry that sustains so many coastal communities. Challenges like that faced by Brexit, which is coming down the tracks at a rate of knots. And that is an issue that will impact Irish waters, with European vessels coming into Irish waters. So there's so many challenges, so I would really urge you to listen to my concerns and that of the fishing industry. I will be sending in submissions on the issues that I do have with this statutory instrument. I'll be sending to you, Minister, so that a more detailed copy, but I want to take this opportunity to highlight 3 or 4 elements that I feel should be highlighted in here today. Number one, I feel that there needs to be sufficient separation between the policing authority and the determination panel. The fact that the determination panel is selected by the SFPA, for me, isn't sufficient separation. And that's something that needs to be addressed. The determination panel could be selected by the AG or indeed the Minister. Number two, I have great difficulty, and the industry have great difficulty, with the fact that where a court of law deems that an infringement hasn't taken place, or they acquit the licence holder, that the penalty points still remain with the licence or with the vessel. That's very hard for me to understand, and it's hard for the industry to understand, and it's something that I feel could be reversed. Number three, where the capacity is being transferred, the idea that the penalty points transfer with each section of the capacity, again, is not consistent with what happens in other jurisdictions in Europe. And that's something I feel needs to be re-examined. It devalues the vessel, it devalues the licence, and it devalues the capacity. And it's not happening in other jurisdictions. And finally, point number 4 is the issue that has been raised by other deputies here as well today, and that is the issue around the burden of proof, and the fact that the burden of proof is heavily in favour of the policing authority. And I don't feel that that's the way that this statutory instrument should be drafted. The fact that the points are assigned to a licence on the balance of probability, as opposed to a higher burden of proof, like beyond reasonable doubt, I think also needs to be re-examined. So they're the 4 main issues. There are other issues. I appreciate the fact that on my invitation that you met with members of the POs and that you consulted with them, but I think there needs to be more consultation. I think we need to keep that communication avenue open with the POs and other representatives of the fishing industry. As I said, Minister, I will not be voting against the government on this one. And I also think it would be misleading of me to give a message out there to the fishing industry that somehow there will be a replacement SI that better represents their concerns. But I would really ask you to take my concerns on board, take the concerns of the opposition on board, open up that dialogue and communication and try to come up with a better proposal, because the challenges facing our fishing industry are humongous, and we need strength, and we need to be able to liaise with them and listen to their concerns. Thank you, Minister.
Sinn Féin, and there are 4 speakers, 10 minutes. Deputy Claire Curran is first.
Gurmahagus las Ciancorla. And I want to begin by commending my colleague, Dr. Padraig McLaughlin, for bringing forward this motion on behalf of the many fishing families across the state who I'm sure will be watching in here this evening and listening to all of the contributions. I recently visited Arranmore Island as part of my role as party spokesperson for the islands, the first of a number of island trips I hope to make in the coming months ahead, in order to learn more about island life as somebody from Roscommon, very much inland, but in order to adequately, understand the life they live and the place that they call home, so I can represent them adequately. I had several meetings on that day, and I engaged with a number of sectors during my visit, all socially distanced, I should say. The one group I met that has remained with me was 3 fishermen. 2 gentlemen who have been fishing for most of their lives, and one around my age, in his 20s, facing an uncertain future, but still wanting a future as a fisherman. You wouldn't imagine that that was a lot to ask for. There were 2 things I was immediately struck by from the fishermen. One was how sick and tired they were of the way they were being treated, with a very obvious sense that they simply cannot continue as things are. But second, an immediate sense that fishing for them wasn't just a job. It's something passed on to them, something they love, but very clearly something that was becoming more and more difficult for them to continue in. And then here comes a penalty point system. And the most bizarre penalty point system of all, where you do the crime, you get the points, you're found to be innocent, but you remain the same. It's crazy. And for many fishermen, this really will be the last straw. The fishermen I met told me of the 54 fishing boats in the 80s, now just 6 full-time fishermen remain. And you refuse to support them and their families, while at the same time super trawlers can travel the west coast from now till April, fish every species going, and our own fishermen are driven out of their livelihoods and fined with penalty points.
Deputy Violet Ann Wynne.
I am pleased to be able to speak on this bill today and outline my sheer disgust that this statutory instrument was signed into law by the Taoiseach in the absence of his second Minister for Agriculture. Minister, I really feel that you and your party have not thought this through. While I understand that you personally were not sitting in that seat when this was signed in at the end of August, I think you urgently need to address the issues faced here. Minister, you sat here on this side of the House back in May 2018 supporting a similar bill put forward by your Fianna Fáil colleague Pat the Cope Gallagher when he introduced a bill calling for the annulment of the same system of penalty points. Your own words are recorded on the record of this House expressing the exact same concerns that we in Sinn Féin look to address here today. Minister, this system of penalty points was contested in the highest court in this land and won, and it was from this win that your party introduced your private member's bill to annul that system. This bill, along with an amendment put forward by Deputy Kenny, was accepted by your party and voted on by the vast majority of this House at that time. Now here we are, 2 years later, debating the same thing, most within the fishing community, along with the main representative organisations in the industry, agree with the need to introduce a penalty point system. The issue here being the burden of proof required. Again, Minister, you also addressed this matter in May 2018. The idea that one can get a criminal prosecution on the balance of probabilities is worrying. Also, the idea that if a decision is challenged in the courts and won, that penalty points are kept on your licence is just complete madness. Imagine the public outrage that this would cause if this was our driver's licence. The idea of innocent until proven guilty on this matter is gone, and this should cause real worry and concern in this House. Minister, I think this is a quite simple motion to get behind. If you and your party colleagues were able to stand up and support a very similar motion that your party put forward in 2018, then there is no reason why you shouldn't be able to support this motion. I would advise erring on the side of caution. Gur Mahagat.
I'd like to thank, first of all, Deputy McLaughlin for introducing this. And I'm just wondering what kind of scrutiny is undertaken by the government parties or the coalition parties when they are introducing regulations like this. Back in July, we had a situation where, under COVID legislation, there was a change in the law brought about to facilitate vulture funds, which was spoken against by all of the Fianna Fáil deputies which were in the chamber at the time, yet voted the other way. Now we have a situation where the regulations, which were opposed quite strongly by all Fianna Fáil deputies, and now they're proposing it. I wonder, is there any communication happening between the various government parties before items like this are brought before this House? I met recently with some inshore fishermen, and we discussed the overall grim economic situation which they find themselves. Apart from Brexit and apart from the pandemic, no adequate supports have been put in place for these fishermen. The answer of the government is to introduce regulations such as these on evidence that you wouldn't get a search warrant to search somebody's house for. So this is part of an overall trend in the executive that I can see, seeking out powers that are inappropriate, attempting to ram them through or place them within statutory instruments where legislators maybe cannot effectively scrutinise them. We've seen this in relation to some of the legislation that has gone through also, and now this rush law, I think, will make for bad law also. The concerns of the fishing community, high up and low down, are being ignored here, and I think it's been pushed through in a lazy way and in a way that is only going to cause problems. I remember dealing with the courts in Kerry, and you would see that the circuit court lists time after time where there was cases which have been put back because of rushed legislation which had been challenged in the courts and delayed. And I think this is probably going to happen again. Thank you.
Thank you, Deputy. Deputy Imelda Munster, to conclude.
I want to first commend my colleague, Pádraig McLaughlin, for bringing this issue forward tonight. I want to start off by saying Fianna Fáil's track record in the Department of Agriculture since coming into power has been an absolute shambles. And I know that when it comes to Fianna Fáil, U-turns and talking out of both sides of their mouth and breaking promises, that nothing should really surprise us anymore. But their U-turn on the penalty point scheme really does take the biscuit. Then, while we were in between ministers for agriculture, the second time, before the third minister was appointed, the Taoiseach sneaked in this statutory instrument. This is a scheme that is seriously flawed, and because of the serious legal flaws in this scheme, it was scrapped by the previous Dáil, including Fianna Fáil. And this same scheme was struck down in 2016 by the Supreme Court, as many other members have referred to. What the fishermen in my constituency, from Clogherhead right the way up to Carlingford, want is fairness. That's all they're asking for, fairness. They're not opposed to a penalty point scheme, but it has to be fair. The main issue raised by fishermen locally is that there's no right to appeal under this statutory instrument, except to the High Court on a point of law. The scheme proposes to enforce sanctions on the balance of probabilities. This is too low a standard of proof, given that the result of sanctions could be the loss of livelihoods for our fishermen. And penalty points will also remain on the licence, even if the fisherman is exonerated in court. And they will remain attached to the licence quota, which will have knock-on effects where a quota or part of a quota is sold on. If sanctions of this type were imposed on motorists or any other group on society, we would not stand for it. Why are unfair and unjust rules considered to be okay by this government for fishermen? It's difficult to understand how the three government parties can stand over such a flawed system. Fishermen are sick and tired of being treated like second-class citizens by successive governments, and the scheme is further evidence that this attitude lives on in the new coalition. Minister, this statutory instrument 318 needs to be annulled.
Thank you very much. Moving on to the Social Democrats, Deputy Holly Cairns.
Thank you, Lasca and Corla. And first of all, I'd like to congratulate you, Minister, on your appointment. Third time lucky, I hope. I welcome this motion that allows us to reverse a poor decision that was made without consultation in the fishing sector. Ireland is required to enact some form of a penalty point system. I don't think anyone disputes that. However, the government's approach has resulted in a process that lacks common sense and puts a further burden on small fishing communities and families. In late August, the Taoiseach, then Acting Minister for the Marine, signed this new system into law. The Irish South and West Fisheries Organisation and other representative organisations were dismayed at this development because there was no consultation with the industry. Many of them found out via an official email a few days later. The government's scheme flies in the face of due process. There are very limited rights to appeal decisions. Decisions can be made on the balance of probabilities, and even if an appeal is successful, the penalty points would still remain on a licence. This is poor lawmaking that erodes confidence in systems that are supposed to be about ensuring better practices. The people of West Cork were further confused by the fact that a Fianna Fáil Taoiseach, who had previously condemned this statutory instrument, was the one who signed it into law. While Fianna Fáil will point out that the minor differences between the regulations are there, these are largely technical, concerning extension of time periods and alterations to oral hearings. However, the core issues remain. After the announcement, commitments were made by the Taoiseach and the new Minister for the Marine to meet with representatives for the sector, which, needless to say, looks and feels like tokenism. There is little point in meeting to discuss concerns after signing this into law. Where was the proactive engagement? Our coastal and island communities deserve better. Fishermen and women should be central to creating a viable and fair process. This point system is another example of the disconnect between the department and the sector. The government's tie-up scheme was deeply unpopular too, as it did not address their needs. It was clear from when the scheme was announced that it was not fit for purpose. Representatives of fishing communities contacted me highlighting that it wasn't sufficient in covering their costs. Fishing is an expensive livelihood in terms of overheads, from maintenance costs to insurance and safety. Their concerns were reflected in reports that very few took up this scheme. The only way successful and progressive policies can be developed is in a genuine partnership with communities and businesses affected. I'm particularly concerned for smaller fishing groups who, despite practising the most sustainable fishing, are often overlooked. At a time when we're all making changes to the way we do business, I would have hoped the department would be open to more proactive measures to help an industry that is vital to so many coastal and island communities. Another issue is concerns around lack of accountability in the Sea Fisheries Protection Authority. The organisation which will administer the point system, we are waiting for a review of that body, and until this is released, it seems ill-judged to give them additional powers. Again, we acknowledge the need for a point system. Not only is it necessary under EU regulations, but it is an important tool to prevent illegal, unreported and unregulated fishing. These practices put the livelihoods of honest fishermen and women at risk, and this needs to be tackled, but there are fairer and better ways than this. We need a system that makes sense, that is fair and transparent. That is the type of system coastal and island communities can buy into and have faith in, and this motion gives us a chance to hit the reset button. This discussion also allows us to focus time on the fishing sector, which is too often relegated around other industries under the Department of Agriculture, Food and the Marine. We need to support sustainable, small-scale fishing, and to do that we need to immediately address the lack of basic infrastructure for them. Too many small piers dotted around our coastline and islands are falling into disrepair and lack basic amenities like slipways. They urgently need investment to preserve the livelihoods of local fishing families and the practice of truly sustainable fishing. The kind of fishing that has existed in rural and coastal Ireland for generations, that is more environmentally friendly and that will keep families living on islands and in other coastal and rural areas. Funding for these piers comes in limited form from the Department of Agriculture, Food and the Marine and the Department of Housing and Local Government and Heritage to local authorities. Having been a member of the Coastal Management Committee on Cork County Council, I can tell you how apparent underinvestment in piers was. At the very first meeting, I had to point out that everybody fighting for the same minuscule amount of funding was counterproductive, and we should instead make the focus, how can we get much more needed funding for piers? I've called for small piers to be made a priority for funding streams for marine infrastructure to support sustainable fishing communities. The fishing sector has been severely impacted by the pandemic. Since March, fishing communities have been calling for greater support due to the significant drop in markets. I've sought a Fisheries task force to help the sector and communities through measures such as tailored social protection mechanisms, consumer campaigns, and I'm making that call again today. This motion highlights serious issues with the penalty point system and allows us to correct a mistake, and I urge all deputies, especially those who represent coastal and island communities, to please support this motion. Thank you.
Thank you. Thank you, Deputy. With your permission, I'm going to allow in Deputy Sherlock. He just missed his slot. It can happen to any of us, so have to. Yeah.
I apologise to the House and to my colleagues. Sorry, I'm a bit late. No, I just, I think the record of the House already shows that Fianna Fáil have had a, quite a strident position on this when they were in opposition, and I just hope that, without reprising all of the issues here tonight, I don't feel it's necessary, but that there should be consistency in the approach that they will take now. That will be consistent to the approach that they had when they were in opposition, and just wish to put that on the record. Thank you, Alaska Corla.
Thank you. Moving on to the regional group, Deputy Rona Murphy. Are you sharing? Yeah.
Deputy Grealish.
Oh, I beg your pardon. Sorry.
Excuse me.
Sorry, I'm jumping ahead of myself. No. Sorry, I beg your pardon. I got caught with the twisting.
Come on, got the Count Corla. I thought you probably hadn't seen me.
Yeah.
I'm so slight, you know what I mean? I just want to start by saying that this feels a bit like Groundhog Day for this statutory instrument, and indeed for the EU Common Fisheries Policy. And I'm unsure what's changed here since the High Court and the Supreme Court struck down this statutory instrument, or indeed what has changed since Fianna Fáil and their coastal representative voted this down in 2018 in a declaration of support for our fishing communities. But let me say from this side, we do support this motion and believe that the statutory instrument is a blunt instrument which is discriminatory and unjustifiable in its application. If it was wrong in 2016, 2017 and 2018, it's wrong now. Fishing communities around the country are right to be outraged and to feel betrayed by Fianna Fáil and the Taoiseach over this. But that doesn't mean that we are opposed to the regulation of the fishing industry. It doesn't mean that we oppose quotas for saving the world's ocean from environmental collapse. I'm in favour of a quota system, and I'm well aware that fishing and the way the quota systems work go well beyond what science and nature tells us is unsustainable and is leading to the ruination and devastation of ocean life. I'm also aware that we constantly set quotas above what science tells us is sustainable. The truth is that the EU Common Fisheries Policy, to which this statutory instrument is attached, is not protecting fish stocks or the greater biodiversity of our oceans. There is a crisis, and there has been a crisis in our fishing communities. There's a crisis in our oceans, and both are a byproduct of the greater crisis on this planet. When people say that the EU fishing policy has decimated our fishing communities, they're often derided by economists who say, look at the stats, and then they tell us we've more people employed, we've greater tonnage of fish catch, and we've exported more wealth generated by the fishing industry than we did before we entered the European Union. The reality is that behind those stats, the type of employment has changed for the worse. The ability of fishing communities to survive and thrive has changed for the worst, and the sustainability of fishing fleets and methods have all changed for the worst. The crisis in fishing is a symptom of a global crisis in our environment, a crisis driven by the same reason and the same basis, the production for profit, regardless of its impact on nature or on human beings. The interests of large agri and food business corporations drive the unsustainable extraction of Earth's wealth and resources, while the interests of the giant oil and gas corporations drive the heating of the globe and the acidification of our oceans. The European Union policy fits into this matrix, despite its claims to the contrary. This debate is not whether you support a system of regulation to protect fish stocks or you don't. It's about whether you stand with the small fishing communities or that you want to pretend that a system of penalty points and unaccountable authority will save the world's ocean. It will not. It will in fact accelerate the trends of driving smaller fishing communities out of business and stacking cards in favour of the mega trawlers and the giant agri-food industry. We support the motion.
The regional group, Deputy Verona Murphy.
Thank you, Alaska Corla. Minister,
Council Regulation EC 1224/2009 requires that actions be taken to ensure compliance with the rules of the Common Fisheries Policy. Clearly, enforcement action is necessitated by our membership of the EU, and Statutory Instrument 318 sets out that enforcement action for Ireland. The enforcement is the imposition of penalty points for serious infringements of the Common Fisheries Policy. But there are three issues I'd like to raise, and the first issue, more likely a question. It should the implementation of the penalty point system be done by way of primary legislation, in that it is setting up new competent authorities such as the Sea Fisheries Protection Authority and the Determination Panel for dealing with the system, and is delegating serious powers to these bodies. My second issue with Statutory Instrument 318 provides that the Sea Fisheries Protection Authority will set up a determination panel to investigate infringements and allot penalty points when it determines that a serious infringement has occurred. This determination panel will determine whether a serious infringement has occurred or not on the balance of probabilities. This is a civil standard of the burden of proof, whereas the penalty being imposed is in the nature of a penalty imposed for a criminal offence, and at least then the burden for the determination panel should be at least be somewhere between a balance of probabilities test and the criminal standard of beyond reasonable doubt. The third issue I'd like to raise is the determination panel can in effect impose what would be considered a major sanction. Other legislation allowing for such sanctions in the case of removal of licence from, such as auctioneers, is primary legislation, and a major sanction such as the removal of their licence must be confirmed by the High Court. If a fishing boat is about to acquire the maximum number of points such that it cannot fish, and taking into account that the sanction follows the ship, it should also require confirmation of the High Court. Anything less than primary legislation to ensure that the rights of the fishermen, for which I remind the House is an indigenous coastal rural activity and employs in excess of 12,000 people in areas otherwise starved of employment other than for tourism. So rural harbour areas such as Killybegs, Howth, Kilmore, the Hook and Duncannon, all harbours where local fishermen contribute greatly to the tourist attractions in many of those areas, which are the finest seafood restaurants this country has to offer. It is not by accident that Wexford and many coastal counties have their fair share of award-winning seafood restaurants. It is down to the hard labour of both the fishing and hospitality sector. There is good reason why I express these concerns, and it is one of personal experience where a penalty point system was being introduced in another sector, which equally had the imposition of penalty points as enforcement for serious infringements. Something that was welcomed within the sector, as it was felt it would serve to implement a standard across the sector for all to abide by. The penalty point regime in this case would, if received, saw 12 points closing the business for a period of 30 days. The point system had credibility until 3 points were applied for the non-wearing of a name tag by the receptionist in the business. The case went all the way to the High Court. It was settled and saw the withdrawal of the penalty point provision in that sector. We must ensure that, as the fishing sector is a rather small cohort, that it is never personal between enforcers and fishermen. Another good reason that having the removal of a licence should be affirmed by the High Court. Really, all is being requested is fair procedures and due process in the manner of which it's appropriate, and that, in this case, is above reasonable doubt and closer to beyond a reasonable doubt. And I'd ask that the House consider it in that light. The people who engage in fishing activities do so in all weathers, often horrendous conditions to put food on our tables. They need nourishment, not punishment. We must support and not discourage them, and unfairness is never a source of encouragement. Thank you.
Thank you, Deputy Murphy. Deputy Noel Grealish.
This penalty points issue is appearing before us at irregular intervals and failing to be fit for purpose each time when challenged. I think it's high time that the Minister and his department come up with a proper plan to deal with this. The Control Regulation EC number 1224/2009 of the 20th of November 2009 is in place for over 10 years now. The Department should have dealt with this properly a long time ago. None of the fishing organisations, big or small, are happy with the way this is written, so it looks like it will be challenged and most likely fail again. It's a waste of everybody's time. In my own constituency, there is a fisheries harbour and 4 offshore islands which are involved in fishing. When the joint Oireachtas Committee published its report on sustainable rural, coastal and island communities launched in the shore on January 2014, sorry, I'm out of breath from running up, launched first, the island was first encouraged by the recommendations about fishing on the islands. They set up a representative group from the islands fishermen, Donegal, Mayo, Galway and Cork. The IIMRO, the Islands Fisher Marine Resource Organisation, which said, sorry, I'm going to have to, my heart is racing. Yeah, I had to run up, sorry about that.
Wait a minute or two,
yeah.
Take your time, take your time.
Yeah, because someone else can take over and I come back again.
Yeah, we'll come back to you, we'll come back to you. Yeah. We'll go to the Rural Independent Group, yeah.
All right, so.
I don't do my Collins, there are 3 speakers.
First of all, I'd like to thank Sinn Féin for bringing forward this excellent motion. There is a centuries-old legal dictum applying in our Irish common law system, overlain by the requirements for administration of justice under Bunarac na HÉireann 1937, that no person can be a judge in his or her own case. Accordingly, it is not the duly appointed judges of Ireland who prosecute people of alleged infringements of the law, but the statutory, separate and independent Director of Public Prosecutions, who presents all relevant and admissible evidence before our courts. Our judges, sometimes sitting with juries, listen to the admissible evidence, and they then decide whether an accused person has committed an alleged offence or not. The test governing the guilt or innocence of an accused person is that the prosecutor must prove guilt beyond reasonable doubt, following which, in the event of conviction, the accused person is sentenced in accordance with the law and generally by the way of a fine or an imposition of a prison sentence. The EU penalty points legislation dating from 2008 has been introduced into Irish law by Fianna Fáil leader An Taoiseach Micheál Martin, supported by Fine Gael on the 26th of August 2020, by means of a statutory instrument, seeks to implement into Irish law the provisions of the 2008 EU Council regulation, being a piece of legislation that was initially put forward and designed to deal with the problems of illegal, unreported, unregulated fishing. Now, once the competent authority, King, has decided it is a serious infringement, then it is a serious infringement, following which the SFPA must proceed to impose penalty on the unfortunate owner of the offending fishing boat. In Ireland, the penalty imposed by the SFPA in the event of repeat offences being committed introduced the confiscation of a sea fishing boat licence. Although we in Ireland might think that determining whether such an enormously damaging and punishing penalty as the confiscation of a sea fishing boat licence is something that we should only be considered on the basis of proof presented beyond a reasonable doubt, our Fianna Fáil and Fine Gael government sadly has chosen to grant the power to destroy a fishing boat owner's livelihood and the livelihoods of the crew members and the support staff through confiscation of the fishing licence on the basis of an offence having been proved to have been committed on the balance of probability. I can think of no other area of our lives where so extraordinarily severe penalty can be imposed on the basis of a probability in circumstances, where the detective, the prosecution barrister, the expert witness, the judge and jury and the person imposing sentence is one and the same person, Minister. This is shocking beyond belief in our democracy. In May 2018, the Dáil voted down a Fianna Fáil motion to have the statutory instrument annulled. The motion was tabled to by the then Fianna Fáil TD Pat the Cope Gallagher. So I ask every Fianna Fáil TD today, why then, within 2 months in government, the Fianna Fáil Taoiseach, only 7 days acting Minister for Marine, does a dramatic U-turn and signs a statutory instrument that the party voted against in opposition into law. Killybegs Fishermen Organisation KFO Chief Executive Sean O'Donoghue criticised Mr Martin's move, made during his short-term acting minister when he was holding the Agriculture, Food and Marine brief. That the system signed in by Mr Martin on August 28 by statutory instrument does not allow for the right of appeal except through a court of law, and penalties can still remain on a licence if the case is thrown out. Sorry, I have a few more minutes.
Oh, sorry.
Patrick Murphy, Chief Executive of the Irish South and West Fish Producers Organisation, which represents 490 fishermen families, has starkly spelled this out when he said that the recent decision by the then acting Marine Minister Micheál Martin to sign statutory contentious penalty points legislation for fishing breaches was dismaying. 2 of Irish South Western Producers Organisation members challenged this legislation in our High Court, and one said Mr Murphy. He said Minister Creed tried again to introduce this flawed legislation with little change 2019. In West Cork, fishing groups were promised a meeting with the Taoiseach by one of our own backbenchers, and of course they were not worth the meeting. Empty promises made yet again by a government that seemingly once again tried to criminalise fishermen and fisherwomen. I myself, when this meeting was being promised to take place, with our Taoiseach assumed what I read, that we would have changes made to the statutory instrument, and only after attending the Irish South West Fish Producers Organisation AGM last week I found out this meeting did not materialise. And in my view, the fishermen of West Cork were hoodwinked, and this was a plan hoping that we all would keep our mouths shut, take our eye off the ball and turn our backs on our fishermen. This motion tonight will not allow this to happen. Every Fianna Fáil, Fine Gael TD and every Green TD who represents coastal communities, who claim to represent fishermen, who fight the high seas, who face the mammoth task day in, day out, with little or no support for the past number of decades. Whether you claim to support those in the bigger trawlers or the inshore fishermen, do not support further destroying fishermen's livelihoods by backing the party line. Stand by your fishermen, whether they be from West Cork or any part of Ireland. If you Fianna Fáil or Fine Gael TDs toe the party line tonight and turn your back on these fishermen and women and their families, it will never be forgotten for decades to come.
Thank you, Deputy Colin. Thanks, John Colin. I would like to acknowledge that this motion is very opportune as we struggle our way to the Brexit deadline. There is 7,500 kilometres of coastline in Ireland. In total, Ireland's total package of agreed fish quota for 2020 is 195,000 tonnes. This is worth an estimate of 275 million to the Irish industry. The fishing industry supports 16,000 jobs, 9,000 directly and 7,000 indirectly. It was very interesting to note that this week that Michel Barnier is very concerned about Ireland's position after Brexit. He said without a doubt Ireland is a member state most affected by Brexit, said the EU chief negotiator on Brexit. He said that the UK have not shown any willingness to compromise on the fisheries. Ireland needs agreement on average 34% of Irish landings taken from the UK waters. This is the voice of the EU. Yet our Taoiseach, as a box-ticking exercise, is adamant that he wants to bring in penalty point system that cripples our fishing industry by putting through a statutory instrument. My job as a politician is to question why a point system would be forced on our fishermen, where they're struggling. In this place to appeal, the appeal process does not remove the penalty points, even if they do not warrant. In conclusion, there must be room for a proper appeal system. Ireland has a 200-mile fishing zone, and this must be protected as being a very valuable resource to our country. In the new Common Fisheries Policy 2021 to 2027 states that small-scale coastal fishery regions would receive greater beneficial treatment. Surely this is all about Ireland.
Very much, Con Corley. First of all, I want to thank Sinn Féin and I will be supporting their motion because there's no question about it. This is absolutely ridiculous. It's like putting the car before the horse. Again, this is what and you see, if the system was that people would be brought to court and that they would get penalty points or get fined or whatever in court, that would be fine. But this is not the way with this. The Taoiseach has signed the statutory instrument, and if people are held up, if fishermen are held up in the high seas and get penalty points, whatever they do, whatever court they'll go to, they won't get the penalty points removed. And Minister McConnell, you're from Donegal, and you understand it maybe better than any one of us. And you opposed this 2 or 3 years ago as part of your party, and Pat the Cope Gallagher did vehemently oppose it, and we all supported him here when he came off the chair and made the case for the fishermen. I want to make the case for the fishermen along the coast of Kerry, from Dingle, Carsaveen, Renard and Kinmare and Steam, who put they have a very lonely, difficult job, and when they fight and overcome everything else, maybe the weather overcomes them then. It's a serious, hard job, and we don't have gold or oil or diamonds in this country, but we have fish, and we should be entitled to fish it fairly and have fair laws applied. I'm saying to you, we're all Irishmen here. I can't understand why the last minister and the last government were trying to bring this in. Myself and Deputy Collins and Martin Ferris, we met with Minister Creed and we laid the line down to him that we weren't going to take what he was proposing. Why does the Taoiseach come along and do this? Who are we beholden to? Is it Europe has pressurised this? Tell us what's going on, Minister, because we don't know. There should be no reason why Irishmen should get penalty points and be penalised without having the chance to fight their case in the court of law. It's very, very wrong. And I'm calling on Deputy Griffin, who's claiming everything except the weather these days, and the Minister, Norma Foley in our county, to come out and do something about this and stop it before it goes to a vote. Because I know if they'll go over there with you, they'll vote together and blow the fishermen out of it. I'm asking you, before it is too late, to cop on and see that what you're doing is wrong. It's unfair and it's not democratic. And it's not fair, Minister.
Now we go to Deputy McNamara sharing with Deputy Pringle and Deputy Connolly. Deputy McNamara.
I'll be very brief. I suppose I'm from East Clare, and there's a distinct divide when it comes to fishing. There isn't a whole lot of sea fishing going on in East Clare. It's all along West Clare, what little of it is left. But, you know, there is a huge imbalance, I think, in the fishing industry, and there's a huge imbalance, I think, in most of the people that you represent, Minister, be it farmers or be it fishermen, and that is their inability to take on a system. You know, there are very big players in the agri-food business, huge players that your department, for one reason or another, often give way to. And then there are lots of small producers, be they fishermen or be they farmers, who go out there and produce an absolutely amazing product, and they don't get the reward for that. And sometimes they feel that they're being penalised and they feel that the system is against them, and they don't. You know, the idea of taking judicial reviews isn't something that they can do. It's not, they don't have access to the High Court. The big players do, but the weak suffer what they must and the strong do what they can. And that's very much what happens, I believe, in your department. I'm not saying it's your fault, but it is the way it is. So I'd like to know how the penalty point system that you have introduced, and we'll wait and listen, how it differs so substantially from the penalty point system that you had annulled, or that your party had annulled. And there may be differences, and I'm willing to listen to those. But I hope it's not around an ability to take judicial reviews in the same way that it was the small publicans, if they were shut down for a day, were to take a judicial review, because it's simply not realistic. People need fairness. People need to be able to produce a product that they've produced for generations, that they've produced in an ecologically sustainable and in an environmental way, as inshore fishermen in Ireland do, as small farmers do in Ireland, and need to get a fair price for it. And instead of being put to the pin of their collar by regulations, by a department, they need to be supported and assisted. Thank you.
To thank Sinn Féin for bringing the motion, and I want to support the motion. And it's actually embarrassing, Minister, to be here and listen to the argument and Fianna Fáil supporting, bringing in the Taoiseach doing it on the 28th of August, a statutory instrument that seems very little difference with the previous one, annulled by the Supreme Court, and previous to that by the High Court in another situation. And it's embarrassing, really, because we really need leadership, and we need a change of direction from COVID, and to realise that we have to support our rural communities, and we have to support sustainable development in every sense of that word. And fishermen are an integral part of the food chain, and I wish we were having a discussion here as to how to support them. They certainly feel isolated, and I can absolutely see why. And I represent Galway West with my other colleagues. We have the Aran Islands, we have Inishbofin, and we have a long coast. And I can tell you that the sense of alienation that's been referred to is palpable in relation to the fishing industry. I am all for sustainability. I am not for overfishing, but I can't do any better than what Breach Smith said earlier. We don't have policies that are sustainable. And then on top of that, we bring in a punitive system that you referred to in your speech as being proportionate, dissuasive and effective. It's none of those things. None of those things. And I wonder at what stage will sense prevail where this chamber will actually listen and as a result of listening to a sensible points being put forward by such an array of speakers here, and do something about it. Let's get rid of this statutory instrument. Let's learn from the Supreme Court and the High Court, but most of all, let's learn from the fishermen on the ground who are telling us this is not possible. It's not fair, it's not just, and it's not proportionate. And the four major points have been mentioned already: the burden of proof, the points remaining despite being exonerated in the court, the multiplying of the points if the quotas are assigned, and of course the restriction of the appeal system to the courts except on a point of law. And how can that be justified? How can when I look at it, I feel what's happened is you've got to the point where you can't say to the EU anymore, we failed to comply with what we're supposed to have done since 2009, with a tiny bit of leeway till 2012. And here we are 8 years later, and the co-funding has stopped, hasn't it? And it's rising by millions. I can't precisely remember. I didn't have a copy of the speech before me, but you mentioned the money that has been stopped and rising. So you've got yourself into a pickle again, because you need that money from the EU. You need to be seen to be doing something, but in reality you're not. But worse than that, it is just dispiriting for the fishermen who are listening to this debate to realise the complete absence of leadership, and when so little would go so far with them. I want to thank Sinn Féin again for bringing the motion. Thank
you, Lashkan Gorda. And I would like to just pay tribute to Sinn Féin for bringing forward this motion, and it's certainly doing what it's designed to do, is basically to put Fianna Fáil on the spotlight in terms of what they've actually done in relation to this and what the Taoiseach has done. And there's been a lot of speculation as to what his motivation was and stuff like that there. And unfortunately, Charlie, I think his motivation might have been to protect you partly as well, because if the Taoiseach did this, it wouldn't come down on you to do it, and you're going to have to do it in relation to your own department when you be coming in there. And you can wash your hands of it now and say, well, it wasn't me that did it, so it has to stay. And you know, it's the first time ever in the history of the state the government law was rejected in 2018 on this issue, on the penalty points issue, when it was put forward by yourself and by the Fianna Fáil party to actually reject it. And now we see that the Fianna Fáil party has brought forward and implemented it. And it just shows, and it's actually interesting, because I was speaking to a number of fishermen today and that there in relation to it, and they wondered, and they genuinely couldn't figure out how this could happen, how Fianna Fáil could say one thing and do something else. And I said, there's an election in between. Fianna Fáil are now in government. They'll say anything in opposition, and when they go into government, they'll do the exact opposite. And it's really brought it home to those fishermen that actually is what happens. And it's probably, hopefully, will bring it home to a lot of people that actually is what is happening here. That is, we can say whatever you want in opposition, and when you go into government, you can do whatever you want then, and you can do the exact opposite, and nobody bats an eyelid on it in relation to it. And so, so this will be. You will pass this through because you have the numbers there, and even despite the fact of your party colleague acting as opposition while in government and saying that, you know, how terrible this is and how much impact this is going to have on the poor fishermen in West Clare, or West Cork, but yet he's going to vote with you anyway to make sure that it's implemented, and that's the sad reality of it. And there's a lot of problems that have been laid out in relation to this penalty points, and they're the same problems that were there in 2018 when it was rejected, and before that as well, when the courts struck it down too. And it is that the burden of proof and also the assignment of the quota, and how the penalty points will pass on, even if, for example, if a boat is sold and the tonnage is split up and goes to 4 different boats, the actual amount of penalty points will go with it as well. And that is the real problem. That's what's hampering the system. And you know, and the fact then that there is no appeal system, or very little appeal system, restricted appeal system within the penalty points as well, and that causes ongoing problems for fishermen. And actually, when you look at the EU regs and stuff like that, there, like it does say that in the Article 90 of the control regulation says that the competent authority of the member state is required to determine the gravity of the infringement in question, taking into account criteria such as the nature of the damage, its value, the economic situation of the offender, and the extent of the infringement and its deception. So where has the economic situation of the offender been taken into account in terms of these penalty points? It's certainly not anywhere that I can see in relation to it. And that is the crux of the problem, and that's why fishermen are so opposed to this. And very many fishermen don't feel that they can ever get a fair hearing from you in government or from the Department of the Marine. And I think the Department of the Marine and the SFPA are part of the problem here as well. It's because there is no feeling amongst the fishing communities and amongst fishermen across the country that I can see that they feel that they actually will get a fair hearing from the Department or from the SFPA. And that is the crux of the problem that it comes down to it. And I think that's where you're going to have ongoing problems with dealing with fishing and dealing with fishery control and fishing regulation. And why there is ongoing problems is because the actual fishermen don't have any faith in actually the bodies that are reporting. Now, you'll argue that, of course, that's the way it always was, and the fishermen don't want it. But that's not the reality of the situation. The reality of the situation is that if fishermen felt that they could work on their behalf and they could have a frank and open discussion with them, you could actually go a long way towards making a system that works. So, unfortunately, this debate this evening will highlight the situation that's there, but you will use your numbers to make sure that the penalty points stay in there, and that's what's going to happen. And fishermen are going to have to live under that system in the future as well.
Thank you, Deputy Pringle. Now, Minister McConnell.
Thank you very much, Laskin Corla, and I'd like to acknowledge Sinn Féin and the motion they put forward tonight. And first of all, as well, apologise to you, Deputy McLaughlin, and a few of your colleagues that came at the very start for the fact that I wasn't able to be present for it. I did get to hear it on transit at the time, but I would have liked to have been here in person, and I'm sorry that I wasn't present at the time, though Minister Hayden was. I'd like to thank everybody for the many contributions tonight across this motion. Many people took the time to take part in the debate and to give the benefit of their views, and I think that has been a worthwhile debate in that regard. It's an important issue. It's one that I took and my party took seriously in terms of the importance of it on the opposition benches as well. And that's why, along with I was opposition spokesperson, as you know, for Agriculture, Food and the Marine, and Deputy Cove Gallagher, who was spokesperson with special responsibility on fisheries, brought forward a motion to the Dáil here in relation to the penalty points SI, which have been introduced in 2018, seeking to have particular amendments and changes made to that SI, and making a very clear request, which we got the support of the Dáil here for, to have those amendments considered. And that's about 2 years ago now. Those amendments in that time have been considered and legal advice sought in relation to how the SI might be amended in a way that was taken on board what the fishing sector had concerns about, and that would at the same time leave us compliant with regard to our obligation in relation to a control authority within the Common Fisheries Policy to have a system of policing our seas and making sure that the Common Fishery Policy regulations were being implemented and overseen. So the SI, which was signed into law then by the Taoiseach at the end of August, took on board two of those amendments in particular in relation to the need for the right to an oral hearing in terms of the determination panel and the appeal panel, and also the opportunity for additional time in relation to making submissions and in relation to seeking those appeals. The other amendments which were brought forward and which were proposed, having been legally considered, were considered not to be possible to accommodate in the SI and keep us at the same time compliant with our obligations under the Common Fisheries Policy and to actually implement the regulation which was outstanding since 2012. I want to acknowledge Christopher Sullivan in terms of his engagement with the producer organisations and input to me over this last period of time, and indeed the many deputies who have spoken to me on it as well, and also acknowledge the meeting that I had with the producer organisations where we discussed this in detail, and indeed where I offered them the opportunity to come forward with further submissions as well to me if they wished me to consider, if they felt that there was an argument that could be made that our obligations could be complied with and in terms of accommodating their requests. So that door is still open. But the obligation on us here is to ensure that we do implement and be legal and follow legal advice in relation to the statutory instruments that we bring forward. And I'm going to outline some of those key issues and some of those key considerations that have informed the content of the statutory instrument, which has been brought forward at the end of August. So I know and I believe that all in the House want to see a strong and vibrant fishing industry that supports employment in our fishing fleet, fish processing and ancillary activities in our coastal communities. And I know we all, and certainly I and my government colleagues, although we're here tonight discussing this issue, are very much aware of the very important moment this is for the fishing sector in relation to Brexit and ensuring that the best outcome and that the sector is protected in relation to that. But as Minister Hayden outlined at the outset, the conservation of fishing resources is in everyone's interest, and it is vital for the future of the Irish fishing industry. An effective regulation implementing the EU point system is necessary to protect the vast majority of law-abiding industry, to preserve the precious and valuable resource in our Irish waters for our fishermen and indeed for future generations. The delay of over 8 years in implementing a point system is something that needs to be addressed, particularly given that the EU Commission has commenced formal infringement proceedings for non-implementation of the point system, with the potentially very significant fines that Ireland may have to pay as a result. Also, the Commission has warned that up to €37 million in EU funding for the fishing sector may have to be suspended indefinitely until Ireland complies with the requirements of EU law and implement a point system. One of the main issues of contention in relation to the application of points has been in relation to the possibility of points being assigned outside of our court system. The 2017 Supreme Court judgment found in favour of the State's position that it is permissible to have a stand-alone system separate to a prosecution through the courts, and that it is permissible to provide for a stand-alone system pursuant to a statutory instrument. The judgment is clear in this, and as the Court understands that criminal prosecutions could take at least 2 years or more, making the points for licence holders ineffective in many cases because the points are to be applied from the date of detection and lapse 3 years from that date. It has also been suggested that the licence holder should have a right to a full rehearing of the case before the High Court. The legal advice that I have is clear that under the Constitution, the High Court has full original jurisdiction and can hear all matters of law brought before it. The legal advice is that it would be highly anomalous, however, if not unprecedented, to provide such a full High Court rehearing of a matter first governed by the procedures which were set down in SI 2020. In addition, it would delay the application of points which would run up to against the timeline set down in the EU regulation that points apply for 3 years with a commencement date of the date of detection. To that extent, it would hinder the effective implementation of this EU law and would not meet Ireland's obligations to implement these provisions. The High Court remains a supervisory and review capacity, or retains a supervisory and review capacity which provides for an appeal on a point of law to the High Court, which is entirely in keeping with a statutory review and appeals process of this nature. Accordingly, the legal advice is that while the High Court retains the constitutional authority to enjoy full original jurisdiction over any legal proceedings, this authority has been circumscribed by the specific appeals mechanism set down in primary and secondary legislation, which overwhelmingly limit just High Court appeals to reviews on a point of law. The issue of points following capacity has been raised today, and the situation is that where points have been built up on a licence in respect of serious infringements and a further serious infringement would result in a suspension of that licence, it is essential that the points are managed so as to dissuade further serious infringements. The SI provides that the points cannot be negated through being subdivided by the licence holder and distributed in reduced amounts among different fishing vessels. A proposal from Ministry that would allow points to be subdivided by the subdivision of capacity across fishing vessels so that each vessel would hold a smaller number of points was examined. This proposal was not accepted, however, as it is deemed that it would undermine the effectiveness of the system and would not meet the objective of the EU regulation. The issue of the standard of proof to be used by the determination panel and the appeals officer has also been raised. The legal standard beyond a reasonable doubt is almost entirely confined to criminal trials and is not applicable to proceedings of a civil nature where the standard used is balance of probabilities. This is the standard that is used for the point system and is an appropriate legal standard. The issue of points for licence holders being removed where the master or owner is found not guilty in criminal proceedings in respect of infringement has also been debated. This proposal would involve both systems being interlinked and would not be stand-alone from each other. We have separate systems involving separate standards of proof between the points and a criminal prosecution. It would lead to the confusion and conflation of evidence and render elements inadmissible. In addition, the legal advice is very clear that points under EU regulation are intended as additional to a criminal prosecution. Accordingly, it could not be argued that while Ireland has both criminal and point systems as required under EU regulation, if we operate the system in a manner whereby the criminal proceedings completely eclipsed this point system, or the point system. Deputies have also raised the issue in relation to infringements and the points to be assigned in relation to that. And it's important to point out in that regard that, that an annex of the EU implementing regulation sets down the details of the infringements and the points that have to be assigned. Furthermore, EU regulations on this matter are very prescriptive in relation to licence holders, leaving little room for further negotiation. For example, fixed at EU level are the list of serious infringements, the number of points to be assigned for each such infringement, periods of suspension and disqualification, deletion of points after 3 years, and deletion of points in certain other circumstances. The issues being raised by industry representatives were previously raised on a number of occasions, including with current and former members of the House, and all such proposals were carefully examined, and any that were considered, as I pointed out at the start, acceptable from a compliance and legal perspective were accepted and incorporated into the 2020 SI. These relate primarily, as I pointed out, to an unqualified commitment in relation to an oral hearing, should the licence holder request one, and an extension to certain timescales, such as for a licence holder to make written submissions to the determination and appeals officer. If the House were to annul SI 2020, it would leave a very significant vacuum in the law in this area, and impact on how Ireland would respond to the EU Commission in respect of the infringement proceedings taken against Ireland and withholding of EU funds under the EMFF. This would be acting in a way that would be showing a responsible indifference to the consequences not only for the fishing industry but also the public purse and Ireland's reputation as a member of the European Union. So in short, Ceann Comhairle, I think I've outlined clearly the process that's been gone through in terms of examining the proposals and the amendments suggested in 2018,
Thank you very much.
Those that have been taken on board and the reasons why the other ones weren't taken on board, and why this is now the best and most balanced SI that can be got, that ensures that we are compliant with our obligations under EU regulation to apply as system. Thank you.
Okay, we move now to conclude. We're going to hear Deputy Pearse Doherty sharing with Deputy Martin Kenny and Deputy Pádraig McLaughlin.
Gormaig at 2.5 minutes. Ceann Comhairle. Well, Minister McConalogue, it didn't take you long to learn the department line. Irresponsible indifference, you claim, coming from Deputy McLaughlin here, who I commend bringing forward this motion to the House. And indeed, your party colleague 2 years ago, who drafted the alternative SI and who brought a motion forward to this House to annul what was nearly an identical SI, which again penalised fishermen in your own constituency and further afield, the first time ever for an SI to be struck down. Yet today you claim that it is irresponsible indifference. What the reality is this is a kick in the teeth to fishermen right across the coast of the state, indeed many of them in our own county of Donegal. These same fishermen who you now want to impose with this regime of penalty points are fishermen who see their livelihood being stolen from them by an overburdensome set of regulations. They understand, particularly the inshore sector, the difficulties in terms of not having adequate quota. They see how super trawlers basically trawl through the fish that is off our coasts, allowing these European super trawlers to plough through their pots, yet when the Navy inspectors are going on board, they're given hours of warning. They cast net, or they catch thousands of fish, only to dump them again because they're a few millimetres too small. These fishermen understand the need for preservation and conservation, but what they do not understand, Minister, is the fact that you have brought in and you stand over this statutory instrument, which is absolutely ridiculous. Thank you.
Minister, this statutory instrument has been debated in this House many times, and we're back here again. And the reality is that the government is doing exactly the same as the last government done. You're absolutely ignoring rural and coastal communities. You're destroying them. And you know, people often think what the fisherman stands for, what people from all parts of the country, just ordinary workers, when they look at the fisherman, they see somebody who risks everything to go out and try and survive. And really what this says to me, what this statutory instrument says, is it says that this government is going once again to back the big shot. That's really what it's about. And the small coastal communities, the small fishermen that are struggling to survive, somewhere, I don't know where it is, whether it's in the Department of Marine or wherever, have decided that the small fisherman needs to be pushed out of it, that they're not sustainable. And this is another element in making that happen. You won't give them quota, you won't give them a chance, you push them into the ground. This statutory instrument will mean that they can board their vessels, that they can put penalty points onto them with no recourse whatsoever. It's there whether they win the case or they lose the case. It's completely arbitrary and completely wrong. And you know, Pat the Cope Gallagher, when he was here, made a very strong point to that. In fairness to him, he fought that corner. And now it's absolutely deplorable that you, his colleague from the same constituency, is doing the exact opposite. You know, I'm absolutely incensed as to how you have come to this position, that you think that it's okay to do this to fishermen in your own constituency and up and down the length and breadth of the West Coast and all coastal communities around Ireland. It's completely wrong, Minister, and I think you know it. In there, you know it's wrong. But somewhere or other, this policy has been put in place by people who are faceless, who don't come into this chamber. And those people need to be stood up to. And if you're going to make a mark as a Minister for Agriculture and the Marine Minister, you need to make that stand. You need to stand up to those people who stand for something that is not really what we are about. That's about something different. That's about looking after vested interests. It's time the vested interests were set aside and the ordinary people were given a chance. And the recognition of that and the reference of that will be if you do the right thing by the coastal communities and the small fishermen around the country. And the first thing you need to do is make sure that this statutory instrument is set aside, because it is completely wrong and you know it.
Minister, this is a really, really sorry saga. And I'm going to give advice, genuine advice, over to you across the floor this evening. You need to get a grip of the Department of Marine. Urgently get a grip of the people who run the Department of Marine. In all my time in politics, in this 18.5 years, I have never come across such a wall of distrust between those that a department are supposed to represent and the department themselves. In all of my years, I have spoken to fishermen and women up and down the coast since I took on the role as Sinn Féin spokesperson for Fisheries and the Marine. In every single sector, inshore, you know the inshore well in Donegal, whitefish, pelagic, no matter what the sector, inshore, offshore, no matter what, they have a huge distrust of those who run the Department of Marine. Huge distrust. They had to take them to court, not once but twice, and they were vindicated. They went to the highest court of the land. These people in the Department of Marine spent a huge amount of taxpayers' money, and they lost again and again. Your party brought forward a motion led by Pat the Cope Gallagher, where the first time in the history of the States was a hugely big moment where you voted down a statutory instrument. And I read over line for line every single speech that was made whenever we put this annulment motion on the order paper, and I read it again today, every single speech line for line. And if you read back, Minister, on what you said and what every single Fianna Fáil spokesperson said that night and what you have said tonight, it's like two different people. I mean, it is shocking, and I can't convey to you how angry, right, these fishing representatives are. Many of them who've supported your party through thick and thin over the years, right? They said to me, hold back on this annulment motion. We'll get a meeting with the new minister. He's from Donegal, and he will understand more than anybody the need to address this issue. He will engage with Pat the Cope Gallagher in terms of the amendments that Pat the Cope brought forward to the previous SI. That would have solved the problem, would have addressed concerns of the fishing industry, would have built trust at last between those who put their lives at risk, to earn a living all around our coast, and those who run this department. It would have been a big, important moment. But here we are again tonight, and your speech reads almost identically to what Michael Creed said 2 years ago. Deeply alarmist speech that he gave, lecturing those across the chamber, talking about the cost, the financial cost. What about the cost of going to the Supreme Court? What about the cost about the South and West producer organisation, who are going to be forced to take a legal case again, and may well win again? This shouldn't be necessary. Minister, one of the comments made by Dara Cleary, Deputy Dara Cleary, former Minister, was that we need a Minister of State for the Marine. That's what he said in 2018. And he referred to Pat the Cub Gallagher and his track record. You absolutely need somebody who's going to get a grip of this department. You will be overwhelmed with all your responsibilities in agriculture. They're immense, they're huge. And yet again, the Department of the Marine will be let run riot on their own, with no minister to hold them to account. They will have warned you of all sorts of unintended consequences. They would have told you about Attorney General's views, legal views, bamboozled you with all of this. But yet when you look at a report from the European Union themselves in July of this year, it's very, very clear that the systems that are in place all across Europe bear little resemblance to this one. This is one where on the balance of probabilities, somebody can be convicted, their livelihood taken away on the balance of probabilities, whereas you and me, if we were stopped by a Garda, would have the right to go to a court, would be presumed innocent until proven guilty. If we were found innocent, those penalty points would be removed. They would not happen, because that is beyond a reasonable doubt. It's our right to go to court. So whoever wrote that script tonight and said to you that it is acceptable that on the balance of probabilities, that is a threshold that's acceptable, is letting you down, is failing you as a minister. So you may well vote tomorrow night in total defiance against every word that every Fianna Fáil TD said. And I wouldn't argue, I read through every single line. There's not a line that I disagree with from every single Fianna Fáil TD who spoke 2 years ago. Charlie, I'm going to say to you, sorry, Minister, I've been informal because we know each other as Donegal TDs. Minister, these fishing representatives feel betrayed. They feel betrayed. You have a huge job of work to do, whatever, if you're going to vote against this tomorrow night, to reach out to the fishing industry and break down the wall of distrust, to stand up to the senior officials in the Department of Marine. It is the view of the fishing community that they are being criminalised, treated like second-class citizens. You must know that from talking to them. This will only entrench their view even more. It'll push the gap further and further. We are an island nation. We have a huge marine resource. We should be enriching coastal communities, not criminalise them. That's the implications of the decision you're making. I ask you, whatever way you're going to vote tomorrow night, to urgently reflect on the need to stand up to those officials and to make a stand as a Donegal man against these people and on behalf of the people you represent.
Thank you very much, Deputy. That concludes our consideration of the private member's business. The question now is that the motion be agreed to. Is the motion agreed to? No. The Choctaw Tar Haven Tarishkana, Aberdish Thaw, and Yatonic Aberdish Neil, Stolim Gulbucher, in case I believe the question is defeated. Vote all. Vote all insofar as the vote has been called. The division is postponed until the weekly division time tomorrow evening at the National Convention Centre. Topical issues. Wish to advise the House that 31 deputies have submitted matters under Standing Order 29A, which will be listed in the official debate. The matter which is raised by the following deputies have been selected for discussion: Deputy Eamon O'Keefe to discuss the commencement of sections of the Public Health Alcohol Bill dealing with minimum unit pricing of alcohol. 2. Deputy Dennis Nocton to discuss the need to redeploy speech and language therapists from COVID-19 contact tracing work to provide support to children. Number 3. Deputy David Stanton to discuss the urgent need to upgrade the R624 road to Cove and the Great Island in County Cork. And number 4, Deputy Chris Andrews to discuss the regeneration of social flat complexes in inner city Dublin, including Pierce House. The House will now take a sanitisation break until 8:42. 8:42. Thank you.